In the heart of Denver, a most historic gathering transpired this fine Monday, where learned attorneys for a group of voters held forth, ardently proclaiming that the erstwhile president, Mr. Donald Trump, ought not to grace Colorado's ballots in the coming year. Their assertion, as I reckon it, hinged on the belief that he, in their view, kindled a rebellion and thus is disallowed by the sanctified U.S. Constitution from seeking office once more. In vehement dissent, Mr. Trump's own counselors rebuffed such notions, suggesting that the esteemed citizenry, rather than venerable jurists, should determine the path of his political destiny. The initial day of this solemn assembly, fated to endure a week's span, unfolded with a painstaking retelling of the tumultuous events that unfurled at the hallowed halls of the U.S. Capitol on the momentous day of January 6, 2021. An erudite Democrat representative, forced to flee for his own safety, and two valiant officers of the law who strove to quell the rabble-rousers, took their turns upon the witness stand. Both these defenders of order expressed deep apprehension for their lives, with one amongst them characterizing the Capitol's violation as naught but a terrorist attack. This litigation, may it be known, is but a singular thread in a larger tapestry of legal skirmishes stretching across this great land, all seeking to preclude Mr. Trump's return to the ballot, citing a certain clause within the Constitution's 14th Amendment. This particular clause, a vestige from the bygone Civil War, aimed to obstruct the ascent of those who supported the Confederacy to high office. Amongst the learned pundits, there exists a division as to whether this clause can be invoked against Mr. Trump, but the consensus leans toward these endeavors meeting a most arduous fate. A fellow named Mr. Eric Olson, donning the robes of an attorney, boldly declared in his opening address, this was an insurrection that Trump led. According to his narrative, Mr. Trump summoned and marshaled the multitude, bestowing upon them a shared purpose, to disrupt the certification of the election, led by Vice President Mike Pence. In support of his contention, Mr. Olson laid emphasis on Mr. Trump's liberal usage of the term fight during his exhortation to his supporters preceding the uprising. Furthermore, he asserted that Mr. Trump wielded his Twitter apparatus to inflame their passions when they arrived at the Capitol. Lastly, it was averred that Mr. Trump intentionally withheld the dispatch of aid to quell the uprising, thus assisting the tumultuous hordes. In rebuttal, Mr. Scott Gessler, representing Mr. Trump, summarily rejected the notion that the former president was complicit in an insurrection. In his defense, he underscored that in the same speech, Mr. Trump had implored his supporters to act with placidity. President Trump didn't engage, asserted Mr. Gessler, he didn't lead a charge, nor did he engage in physical conflict with legislators or challenge President Biden to fisticuffs. Instead, he delivered a speech urging peaceful and patriotic protest. He maintained that the removal of Mr. Trump from the ballot would transgress the principles of democracy, affirming that the ballot itself should serve as the crucible of judgment. With the stage set, the initial witness, a valiant officer of the District of Columbia Police Force, Mr. Daniel Hodges, took to the stand. A video bearing witness to the chaos was presented, filmed by Mr. Hodges's body camera, displaying instances where people endeavored to wrest his riot baton from him. In addition, these unruly constituents accused him of betraying his oath by preventing them from infiltrating the Capitol. After each reel, Mr. Hodges recounted the ordeals he had endured, relaying tales of a man seeking to gouge his eye with his thumb in a frenetic altercation. Further footage depicted Mr. Hodges and his compatriots valiantly striving to thwart a tide of individuals who were forcing their way through a passage within the Capitol. Using shields they had seized from fellow officers, the rioters pinned Mr. Hodges against a door frame, tearing away his gas mask as the crowd pressed upon him, causing him great torment. I cannot recollect all the distinct ways in which I was assaulted, Mr. Hodges testified, and he confessed to the fears that had besieged him, not only for his life but for the sanctity of the hallowed chambers, Congress, the Vice President, and the well-being of our democracy itself. Next, a gentleman by the name of Mr. Winston Pinion, who once served as a Capitol police officer, took the oath and spoke of his hours spent engaged in a vigorous hand-to-hand skirmish with the insurrectionists within the Capitol's walls. At one point, the throng knocked him to the ground and seized his baton, and he harbored concerns that they might gain access to his firearm. Mr. Pinion avowed the affliction of post-traumatic stress disorder and disclosed that he resigned from the police force 9 months after that fateful riot. Further elucidating the harrowing events of that infamous day, Representative Eric Swalwell from the great state of California offered his testimony. He recounted the dread that enveloped him and his fellow lawmakers as they were evacuated from the hallowed chamber of the House, with the marauding mob drawing nigh. It was with bated breath that they monitored Mr. Trump's Twitter account, for his castigation of Vice President Pence only served to further inflame the passions of his supporters who were converging upon the Capitol. We interpreted it as a target had been painted on the Capitol, Representative Swalwell averred. However, it is with a heavy heart that I must inform you that 2 former officials of the Trump administration, who were slated to bear witness on behalf of those who brought this suit, withdrew their participation at the 11th hour, as was revealed to the court. This episode cast a pall of uncertainty over the proceedings. Ratified in the Annus Mirabilis of 1868, the 14th Amendment bequeathed citizenship to those born or naturalized on the soil of this nation, extending the mantle of civil rights and legal protection to all, including those who had once suffered the yoke of servitude. In addition, a lesser-known segment of this amendment, Section 3, barred those who had sworn fidelity to the Constitution but subsequently engaged in insurrection or aided the enemies of the state from holding office. Mr. Trump, for his part, has brushed aside these legal endeavors as a form of election interference, a claim reiterated by his spokesperson, Mr. Jason Miller, who was present at the courthouse to articulate this perspective. The plaintiffs in this case have directed their suit against the distinguished Secretary of State of Colorado, a lady by the name of Jenna Griswold, who, as the chief custodian of the state's electoral processes, holds the prerogative to decide whose names shall grace the ballots. She herself has expressed a belief in Mr. Trump's involvement in an insurrection but has deferred to the court to arbitrate whether his name ought to be inscribed on the hallowed scroll. Both Mr. Trump and the state's Republican Party have entered the fray, seeking to influence the course of justice. These valiant voters, in their pursuit of justice, have enlisted the assistance of an organization known as the Citizens for Responsibility and Ethics in Washington, a vigilant watchdog entity that previously achieved the removal of a county commissioner in New Mexico due to his involvement in the events of January 6. Similar legal endeavors are unfolding in various corners of this vast nation, and in the months to come, courts will render their judgments on whether Mr. Trump's name shall grace the ballots as the Republican primaries take center stage. The Grand Minnesota Supreme Court itself is slated to convene and deliberate upon this matter, with the argument scheduled for Thursday. The focus of this day's proceedings lay chiefly upon the events of January 6, but in the days that follow, Judge Sarah B. Wallace shall have the privilege of hearing from learned experts on a variety of pertinent matters, including the frequency with which the Secretary of State has excluded candidates from the ballot, the implications of electing an unqualified individual to the presidency, and the critical question of whether Mr. Trump's actions on that fateful January day amount to participation in an insurrection. It must be noted, as the shades of evening descend, that Mr. Trump, through his legal representatives, beseeched Judge Wallace to recuse herself from this case, asserting that her impartiality was compromised due to her contribution of $100 to an organization formed in the wake of the January 6 incident, known as the Colorado Turnout Project. The judge, commencing the day's proceedings, firmly asserted her intent to preside over the matter, disavowing any preconceived notions regarding the events of January 6 or Mr. Trump's involvement. The saga continues, my dear readers, and as the legal wrangling unfolds, the nation watches with bated breath to see how this chapter in its history shall conclude. Yvonne Wingate Sanchez contributed to the dissemination of this report, and we shall remain vigilant in our quest for truth and justice.